Objection, the chair is authorized to declare a recess of the hearing. I will now recognize myself for a 5-minute opening statement. Today's hearing will continue the subcommittee's investigation into the matter of Maher Arar and this administration's policy of what has been described as rendition to torture. Today, 4.5 years after Chairman Conyers' initial request, Today, 4.5 years after Chairman Conyers' initial request, the Inspector General's report on this matter is finally being released to the public in a redacted form. I especially want to commend the Chairman, Mr. Conyers, for his work on this and for his efforts to bring out the truth on this terrible incident. I am pleased to be joined by our colleague, the gentleman from Massachusetts, Mr. Delahunt, the Chairman of the Subcommittee on International Organizations, Human Rights and Oversight, who will be co-chairing this hearing. The gentleman has done an extraordinary job of investigating this matter, and I am pleased to continue our partnership investigations. We will now proceed, and I amend what I said a moment ago about the 5 minutes. We will now proceed to members' opening statements. As has been the practice in the subcommittee, I will recognize the chairs and ranking members of the subcommittees and of the full committees to make opening statements. In the interest of proceeding to our witness and mindful of our busy schedules, I would ask that other members submit their statements for the record. Without objection, all members will have 5 legislative days to submit opening statements for inclusion in the record. The chair now recognizes himself for 5 minutes for an opening statement. Today, 4.5 years after Chairman Conyers' initial request for an investigation, we will begin to get the facts about the administration's transfer of a Canadian citizen, Maher Arar, to Syria, a country listed by our State Department as engaging in torture. Specifically, we will examine the report of the Department of Homeland Security's Inspector General on the case. Maher Arar, a Canadian citizen, was seized by our government as he was changing planes at Kennedy Airport while returning from vacation in Tunisia to his home in Canada. Our government detained and interrogated him for 2 weeks and then handed him over to the Syrians, who imprisoned him for 1 year and tortured him. We have been told by the administration that the United States takes seriously its obligations under the Convention Against Torture and under the laws of the United States not to hand people over to governments that will torture them. We have been specifically told by Attorneys General John Ashcroft and Alberto Gonzalez, as well as by Secretary of State Condoleezza Rice, that in the case of Mr. Arar, the law was followed, that the United States obtained from the Syrians, quote, assurances, unquote, that he would not be tortured. But as we now know from the Canadian government's commission of inquiry into this case, the Syrians did what our government says they always do. They tortured him. It has taken 4.5 years since Chairman Conyers' original request in a December 16, 2003 letter asking the Inspector General to investigate this matter and to get some of the facts in the open, but we finally have this redacted report. Today, the Inspector General's report with classified material blacked out is finally being made public. It is, even in its redacted form, a deeply disturbing document. The facts it lays out raise serious questions, not just of fact but of law, that demand answers. What does the report reveal? From the report, quote, the INS concluded that Arar was entitled to protection from torture and that returning him to Syria would, quote, more likely than not result in torture. Quote, the assurances upon which INS based Arar's removal were ambiguous regarding the source or authority purporting to bind the Syrian government to protect Arar. In other words, the INS concluded he was probably going to be tortured and that the assurances provided that he wouldn't be were ambiguous as to whether they were authoritative or what the source was. Quote, the validity of the assurances to protect Arar appears not to have been examined. Close quote. In other words, it is reasonable to conclude that the INS knew or fully suspected that we were handing over Arar to probable torture. The government took steps to conceal Mr. Arar, and to conceal his whereabouts and to prevent him from contacting his family or from speaking with counsel. The General Counsel of the Department of Homeland Security insisted that the Inspector General sign an agreement, reprinted in the report, to give the Department virtual veto power over what could be shared or made public, even setting conditions on the circumstances under which information could be shared with Congress. It was, to put it mildly, a case of allowing an agency to set the rules for an investigation of its own conduct. Now that this report is public, people will be able to read it and judge for themselves whether the delay and the secrecy was excessive and whether that delay and secrecy was part of an effort to protect the security of the nation or part of an effort to protect the administration from having immoral actions made public. People should read this report and decide for themselves. We also need to consider whether the law was violated in this case. The Inspector General's report stated that he has been unable to determine whether or not laws were violated, at least in part because key witnesses refused to cooperate with his investigation. but the report seems overly cautious in its conclusions. A fair reading of the facts revealed in the report indicates that the administration knowingly violated its obligation, the obligation this nation has agreed to observe under the Convention Against Torture. A fair reading reveals that the administration knowingly violated our nation's laws against conspiracy to commit torture. A fair reading reveals that the administration knowingly violated our laws governing the treatment of persons passing through our ports of entry or who are detained on our soil. A fair reading would seem to indicate that administration officials, including Secretary of State Condoleezza Rice and Attorney General John Ashcroft and Alberto Gonzales, materially misrepresented the facts and misled the Congress in their testimony on this issue. We need to strengthen our laws to ensure that our nation does not again become a party to torture by a country like Syria, which the administration has identified as a country that tortures and is a state sponsor of terrorism. This case and the rendition policy generally gets more disturbing with each bit of information we obtain, and the fact that it has taken more than 4 years to obtain even this limited amount of information in the report is itself very disturbing. I look forward to the testimony of our witnesses, and I can assure my colleagues that this is not the end of our investigation. I yield back the